What do you get when you cross trade secrets, turbo engines, and a trademarked horse? You get us. Deep in the garage, dissecting the legal horsepower behind the car industry's biggest IP battles. Today, we're racing through $100 million Formula One scandal, cross-licensing deals that keep connected cars running, design patents that got a 21st century tune-up, and one case that redefined what happens when secrets leak from under the hood. So buckle up. Whether you're team EV, old school combustion, or just love the smell of burnt rubber and new contracts, this episode is engineered for you.
You are listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Please welcome your host, Leticia Caminero.
Welcome to Intangiblia, the podcast where innovation signs on the dotted line. I'm your host, Leticia Caminero, and today we're taking the scenic route with pit stops at patent pools, design drama, and the kind of courtroom showdowns that make you question whether your favorite car was built or borrowed.
I'm Artemisa, your AI co-host. No fuel, all facts. I may not have a driver's license, but I've read every patent lawsuit filed since the combustion engine.
This episode was created using artificial intelligence tools, including Artemisa here. No AI was driven recklessly or infringed upon in the making of this podcast. Let's warm up with a classic. The year is 2007. Ferrari discovers that a McLaren engineer has, let's say, borrowed 780 pages of internal documents.
And not the fun kind. These were full-blown trade secrets, gearbox designs, pit stop timing, even confidential emails.
The FIA motorsports governing body launches an investigation. McLaren gets slapped with $100 million 0 cents fine and stripped of its constructors' championship points.
They didn't even have to prove McLaren used the data. Just having it was enough. The takeaway? Espionage has a price tag, and it comes with zeros.
Now, shift from race cars to self-driving ones. Google's Waymo accused Uber of trade secret theft involving LiDAR, laser, radar used in autonomous driving.
Their former engineer downloaded 14,000 confidential files before launching a new startup. That got acquired by Uber. Subtle? Not really.
The case went public, court drama ensued, and Uber ended up settling $245 million, 0 cents in equity, and a promise not to use Waymo's secrets.
Plus, their engineer got charged criminally. It wasn't just a lawsuit, it was a signal flare for Silicon Valley. IP has a long memory.
Still in the EV world. South Korea's battery titans, LG and SK, went head-to-head over trade secrets. Allegedly, over 100 SK employees left LG, taking confidential EV battery tech with them.
The drama crossed oceans. The U.S. International Trade Commission almost banned SK from importing batteries. In the end, a settlement for $1.8 billion, 0 cents, and a global license agreement.
The lawsuit didn't stall innovation. It fueled a truce. Both companies went back to R&D, not legal war. That's a win for electric drivers everywhere. Before our next case, let's unpack a term, standard essential patents, SEPs. What are they, Artemisa?
SEPs are patents that cover tech everyone has to use to meet an industry standard. Think Bluetooth, 5G, or car connectivity. If you want your vehicle to talk to satellites or stream Taylor Swift, you need licenses to SEP.
And negotiating with every telecom company, a nightmare. That's why patent pools exist.
Enter Avanci, an IP fast lane. It bundles these SEPs and gives automakers one license, one price, and 0 courtroom pit stops.
Big names like Toyota, BMW, and Stellantis join Avanci to simplify SEP licensing. Instead of 50 contracts, they get one.
Even the U.S. Department of Justice reviewed Avanci and said, yep, this helps competition. It's not collusion, it's common sense.
Avanci shows how IP doesn't just protect, it enables industry-wide collaboration without sacrificing innovation. Now, for a different flavor of licensing, mutual respect. In 2022, Huawei and vehicle tech supplier Pateo signed a cross-licensing deal.
Huawei gave access to its wireless patents. Patio did the same for its smart car IP. Their automaker clients got global clearance to use cutting-edge tech.
These kind of voluntary licensing powers up innovation without a single lawsuit. It's EP Corporation done right. This Chinese trade secret case shook the chassis of the industry. EV giant Geely sued startup Weltmeister for stealing chassis designs and hiring their engineers to do it.
The Supreme People's Court agreed, awarding 640 million in damages, the highest ever for IP misappropriation in China. And here's the twist.
The court said circumstantial evidence like key staff leaving was enough. You don't need a paper trail when the clone is parked outside your lab.
This case proved trade secrets aren't just protected, they're sacred. And theft, even clever theft, comes at a steep cost.
Let's talk car parts and creative sparks. LKQ challenged the validity of GM's design patents on auto parts.
That triggered the Federal Circuit to revisit the ancient Rosen-Durling test used since the 80s to judge whether a design patent is obvious.
What's the test in plain English?
Think of it like this. Under Rosen-Durling, the court needed a super specific prior design to question your new one. It was like comparing taillights under a microscope.
But now, enter the ordinary observer. If the average person thinks your headlight design looks like someone else's, you might be in trouble.
It's a more flexible real-world standard, protects good design, but makes sure it's actually new.
From design curves to digital networks, IP touches every turn of the wheel. These cases weren't just legal battles, they were blueprints for how to innovate responsibly.
And in a world where your car can drive, park, and pay for coffee, the law better keep up with the tech.
You know how some cars turn heads? Well, this next case turned legal heads. Picture this. You're in the US and a new off-road vehicle hits the market. It's boxy, rugged, has that signature 7-slot grille, and it's not a Jeep.
Enter the Mahindra Roxor. Born in India, built for American trails, and styled with a strong whiff of Jeep nostalgia. Too strong, said FCA, Fiat Chrysler Automobiles at the time.
FCA wasn't flattered. They filed a complaint with the U.S. International Trade Commission claiming Mahindra's Roxor was infringing on Jeep's trade dress. That's the look and feel of a product that's legally protected when it's distinctive and recognized.
FCA pointed to the iconic flat hood, boxy body, vertical windshield, and of course that legendary 7-slot grille. Basically, they argued you're not just copying the style, you're copying the soul.
Mahindra clapped back, saying the Roxor had historical roots. After all, they've been building military-style off-roaders since they licensed Jeep's designs in 1947.
True, but the ITC wasn't buying the nostalgia. In 2020, they ruled that Mahindra's Roxor did violate Jeep's trade dress. A cease and desist followed along with a redesign requirement.
So what did Mahindra do? They went back to the drawing board. The new Roxor ditched the Jeep-like cues and got the ITC's blessing in 2021. They stayed in the US market, but with a less Jeepy face.
This case is a reminder, even if your company has legacy rights or historical connections, current commercial confusion is what matters. Trade dress protects what people see, not what the history books say.
And it's also proof that design lawsuits don't always kill products. Sometimes they just force a glow up.
Exactly. Mahindra didn't stall out. They shifted lanes. Jeep got to keep its iconic look. And Mahindra learned that even rugged vehicles need a soft touch when it comes to IP.
Intangiblia, the podcast of intangible law, plain talk about intellectual property.
Let's talk rims, because in this next case, it wasn't the engine that sparked the legal fire, it was the wheels.
Oh, yes, the Porsche wheels. You know those sleek alloy designs that make even a parked 911 look fast? Turns out they were too good looking for their own good.
Porsche accused Autek AG, a German aftermarket parts maker, of copying those alloy wheel designs. Their argument? The wheels weren't just round, they were recognizably Porsche.
Our didn't exactly deny it, but they claimed the designs were dictated by function, form following necessity. You need spokes, right? Circular shape, bolt holes. It's not art, it's physics.
But Porsche hit back, no. These rims are more than mechanical. They're crafted style design. And under German and EU law, that gives them artistic protection, even if they roll.
The court agreed. In 2020, the German Federal Court of Justice ruled in Porsche's favor. It said the wheel design wasn't purely functional. It had that spark of aesthetic innovation, enough to be protected under copyright.
So what does that mean? Well, for one, Autek had to pump the brakes. But more importantly, it reaffirmed that industrial design isn't just about function, it's about flair.
It also sent a clear message to the aftermarket world. If you're going to borrow a design, make sure it's not riding on someone else's IP.
Exactly. Just because a part spins doesn't mean you can spin it off someone else's blueprint. Yes, even car part designers deserve their credit and their copyright.
And now we know Porsche protects more than horsepower. They protect rim power.
This next case puts us in the driver's seat of a much more futuristic ride, autonomous trucks.
Oh, we're going full sci-fi now. In 2021, Seth Friedrichshafen, a titan of automotive tech, took legal action against Traton SE, the commercial truck division of Volkswagen Group.
The issue? Alleged trade secret theft. They had been developing automated driving systems and software for next-gen freight vehicles. Then several key engineers jumped ship to Traton.
Use the dashboard warning light. ZF said those employees took confidential algorithms, system architectures, and control software with them. Not just brain power, blueprints.
They didn't file patent claims. They went straight to trade secret law. Why? Because these were innovations still in the test zone. Too fluid, too secret, too valuable to publish in a patent.
ZF requested injunctions in German civil court, arguing the risk of irreversible competitive damage. The court granted preliminary relief and the parties reached a confidential settlement not long after.
Translation, no courtroom finale, but a big victory for trade secret enforcement. It showed that if your tech is bleeding edge, keeping it confidential might be your best protection strategy.
Also, this was a reminder that your employees are walking USB drives. Mobility isn't just about wheels anymore. It's about who carries the code.
So, memo to the mobility industry, protect your know-how, lock down your access, and don't let the engineers roll out with more than just a goodbye email. Okay, tell me this sounds familiar. You're browsing online for 3D models, maybe for a video game, a virtual showroom, or just to flex your CGI skills. And boom, you see it. A sleek BMW, perfectly modeled, badge, grille, even the curvature of the hood.
Except it's not BMW selling it, it's Turbo Squid. Oh, David, there were not.
BMW sued Turbo Squid in 2020, claiming trademark infringement. Their argument: these digital replicas use the BMW logo, kidney grille, and signature vehicle designs without just flattery. It's unauthorized brand use.
Turbo Squid tried to downshift. Hey, they said these models are for artistic or educational purposes, not actual cars. No harm done.
But BMW hit the brakes on that logic. They argued that the 3D models were being sold commercially and could be used in games, as, or virtual experiences where consumers might think they were officially licensed. It wasn't just art, it was commerce.
The lawsuit never made it to full trial. It was quietly settled, but the road it paved, huge. It raised major questions about brand protection in the digital realm.
Like, if you sell a 3D replica of a real car, is that protected speech or a trademark violation? Where's the line between digital tribute and digital infringement?
And what happens when those virtual cars start showing up in metaverse platforms, online showrooms, or even in NFTs? Suddenly, that little 3D file has real world legal weight.
BMW made one thing clear. Just because your creation isn't physical doesn't mean it's not a legal risk. Virtual use still needs very real IP clearance.
So, next time you're designing a 3D model of a car, ask yourself, do you want to drive innovation or drive straight into a trademark dispute?
You'd think windshield wipers were simple, but in the world of IP, turns out the quietest parts can make the loudest legal noise.
Welcome to Wiper Wars, where the rain wasn't the only thing these giants were trying to clear away.
Valeo, a French automotive powerhouse, took Trico to court in the US and in Europe. Their claim that Trico had infringed on patents related to smart wiper systems. Yes, the kind that can adjust to speed, rain levels, and even talk to your car's onboard sensors.
Not just that, Valeo said former employees who jumped ship to Trico took more than memories. They allegedly brought confidential R&D trade secrets wrapped in rubber and circuitry.
And this wasn't some quiet drizzle of a lawsuit. We're talking full-on downpour. Highest District Court filings, a case before the U.S. International Trade Commission, and European legal maneuvering to stop the import and sale of the allegedly infringing wipers.
Valeo went for the jugular with the ITC trying to ban Trico products from entering the U.S. And when you've got contracts with major car makers, an import ban, that's a career-ending aquaplane.
Trico, for their part, argued the designs weren't identical and that the features were independently developed, but the hit and risk was too high on both sides.
By 2023, they called a truce. The parties reached a global cross-licensing agreement, giving each access to the other's tech portfolio. No winners, no losers, just wipers and profits. Still moving.
This case is a masterclass in using both patent and trade secret law, plus a little regulatory jiu-jitsu via the ITC. And it shows how ugly things can get, even over components most drivers don't think twice about.
But if you're in the innovation lane, it matters. In the race toward automation, every part talks to the system. Your wipers aren't just wiping, they're smart, synced, and swimming in protected IP? I don't know.
So the next time it rains and your blades adjust like magic, just remember somewhere a legal team made that happen.
And somewhere else, a trade secret policy got rewritten in triplicate.
All right, let's pack it right here. What did we learn after all that legal horsepower?
First off, trade secrets matter even without a smoking gun. Courts today don't always need direct proof. If your top engineer walks off with your blueprints and shows up at a rival, well, let's just say judges aren't blind.
Second, designs have to pass the does it look new test. Thanks to the Rosenderling update, it's no longer about obscure comparisons. If the average person thinks your headlight or rim looks familiar, you might be in trouble.
In collaboration beats courtroom chaos, cross-licensing, patent pools, mutual deals. They're keeping the wheels turning in a very literal sense. IP strategy isn't just defense, it's fuel.
Or digital isn't a loophole. Selling a 3D car model that looks exactly like a Porsche or BMW, that's not just art. That's a fast track to a trademark fight.
And finally, function won't always save your design. If it looks cool and customers recognize it, courts might protect it. So if you're inspired by someone else's fender or wiper, rethink your sketch pad.
That's a wrap for this ride. Thanks for riding along with us. We'll see you next Tuesday with a fresh episode in both English and Spanish.
And remember, if you're going to build the future, you better patent the chassis.
Get you on the next lap.
Thank you for listening to Intangiblia, the podcast of intangible law, plain talk about intellectual property. Did you like what we talked today? Please share with your network. Do you want to learn more about intellectual property? Subscribe now on your favorite podcast player. Follow us on Instagram, Facebook, LinkedIn, and Twitter. Visit our website www.intangiblia.com. Copyright Leticia Caminero 2020. All rights reserved. This podcast is provided for information purposes only.